Good afternoon. The court's going to take up the next case. This is cause number C200098CPS in the interest of Nevaeh Marie Diaz, a child. The case is set for a bench trial today. The trial is being conducted pursuant to emergency orders of the Texas Supreme Court via Zoom video conference. Participating in the hearing today on behalf of the department is caseworker Darcel Stewart, supervisor Isabella Reyes, and regional attorney Samantha Jordan. The mother of the child is Julie Monique Hinosa, and she is participating in the hearing today with her attorney Nathan Butler. The father of the child is Julian Andrew Diaz Jr., who I understand is incarcerated in a federal prison facility. He has signed a waiver of service that's on file with the court. The court would take possession notice of the court file to the extent it reflects that Mr. Diaz has not filed with the court any request for a court-appointed attorney. No attorney purporting to represent him is entering a appearance in the case on his behalf, and he's not filed any request for a bench warrant or otherwise to appear at the trial in this case. The attorney and guardian ad litem for the child is Emmett Fleming, and Mr. Fleming is participating in the hearing today. The child is excused from participating in the hearing today. As I noted, we're set for a bench trial today. Ms. Jordan, where does the department stand on being ready to proceed with the trial today?
Judge, we are ready to proceed, and I believe we have an agreement with the exception of Dad as he's in prison, so we cannot reach him, but we're ready.
All right. There's no objection. I'd ask you to state what you understand the proposed agreement as it is between the parties that are present today. And then I can confirm whether or not that is their understanding of any agreement. Thank you.
Thank you, Your Honor. The agreement would be joint managing conservatorship between the mother and the paternal grandmother, Brenda Bounthavong. I'm sorry if I mispronounced that. Grandma will determine primary residence of the child. Mom will pay child support according to the minimum wage guidelines. It's $25 a month cash medical support and 50% of uncovered medical bills and deductibles. Her visitation would be unsupervised, standard possession order. As to Dad, he would be named a possessory conservator. We'd ask that he pay child support at the minimum wage guidelines starting once he's released from incarceration. And his visitation would be supervised and at the paternal grandmother's discretion.
And you mentioned cash medical support. Did you say that was $25 a month?
Yes, for both parents, $25 a month cash medical. Yes, Your Honor.
Then the paternal grandmother would be obliged to arrange for health care and dental insurance for the child or enrollment in applicable government benefit programs, and the parents would each pay 50% of any uninsured costs.
Yes, Your Honor.
That's your understanding agreement. All right, thank you. All right, I'll start next with Mr. Butler regarding the proposal that was made by the department or the proposed agreement. What is your understanding on that agreement? Is that correct?
That is correct, Your Honor. The only issue I see, my client's definitely in agreement with it. I did notice it appeared this morning, I believe, CASA filed a letter that they indicated was from the father, intended for the court. However, it was in Spanish, so I have no idea what it said.
You were saying that was filed in this case today?
I believe it was filed this morning. I think I saw it come in. I could be, maybe I'm
Mr. Butler, I think you're referring to a different case.
Is it? Okay.
Yes, sir.
Okay. That may be, I may have been confused when I looked at it.
Okay. Well, then I gather you're in agreement. Otherwise, then, because I'm looking at the court file online, and at least as of now, I don't show anything that was filed on
yeah.
behalf of Mr. Diaz.
You know what, Your Honor, I think that was on my 3 o'clock. I had them confused.
Okay, thank you. That's fine. I understand. All right. Mr. Fleming, your position on the orders requested.
Judge, I'm just glad that Mom has pretty much jumped on the program. So I'm in agreement. Nevaeh always really wanted to have time with her mom, and this will work for that. So I'm in agreement, Judge.
Okay, thank you. All right, well, Ms. Jordan, I think since we have one party who's not here and participating in the trial, I think we'll need to hear some evidence, at least as it relates to his situation, before the court makes any ruling on the orders requested. So we're ready to proceed. I'll ask, let's see, Ms. Stewart and Ms. Hinojosa, if each of you could raise your right hands, please. Each of you solemnly swear or affirm any testimony you give today before the court will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. All right, Ms. Jordan.
Thank you, Your Honor. I will call Ms. Stewart.
Okay, thank you.
Ms. Stewart, will you please state your name for the record?
Darcel Stewart.
And how are you employed, Ms. Stewart?
Through the Department of Family and Protective Services, I am the caseworker assigned to this case.
Okay. Where is the father currently?
He is currently incarcerated at Three Rivers Prison.
Okay, and that's a federal facility?
Yes, ma'am, that's correct.
Okay. What is he incarcerated for? What are his charges?
I would have to go back to confirm those charges. I cannot think of them off the top of my head.
Okay. Do you know how much longer he has on his sentence?
He's got quite a while to go.
Okay. Do you know if he's up for parole anytime soon?
No.
At the facility he is currently in, has he had the opportunity to work on any services, take a parenting class, anything like that?
That I am aware of, no.
Okay. While he's been incarcerated, has he had any contact with Nevaeh?
I think he's had some small contact with Nevaeh in the beginning of this case, but here in the past few, probably 6 months, not that I'm aware of.
Okay, and was that via letter?
If I'm not mistaken, I think it was a letter that he had wrote to her. Then I think maybe he had called and wanted to talk to her on the phone, but Nevaeh did not want to speak with him.
Okay. Well, right now he's not in any position to care for this child, correct?
That is correct.
Okay. So what is the department asking for regarding visitation for him going forward?
That Miss Brenda, the paternal grandmother, can, as far as visitation, make the decision on visitation as far as when she would like that visitation, how long that visitation is. If she feels it needs to be supervised, then she can find an appropriate person, if not herself, to supervise those visits.
Okay. And why would that visitation setup be in the best interest of this child?
I feel like that would be in the best interest for Nevaeh, just because of the fact she has not had much contact with her father. And so I feel like just having those visits set in place for now would hopefully help her feel more comfortable in transitioning if she chooses to visit with her father.
Okay. Earlier I stated that the department would be asking for the father to pay child support. Do you have any reason to believe that once he is released, he would be unable to earn minimum wage?
No, ma'am.
Okay. And are you aware of any other children that he has other than Nevaeh?
That I am aware of, it's just Nevaeh.
Okay. Where is the child currently placed?
Nevaeh is currently placed with her grandmother, Brenda, and I can't say her last name very well either. It's Brenda and Patrick.
Okay, and how's everything going in that placement for her?
I know it's going well. Nevaeh does well there. She thrives there. They take care of her needs. I know Nevaeh has expressed to me that she would like to go home with her mother, and her mother has made significant progress in making the 360 and working her services. But she is residing with them and she is doing well.
Okay. The contact that she's having, that Nevaeh is having with mom right now, is that going great?
Yes.
Okay. That's all I have, Your Honor. I will pass the witness.
Thank you. Mr. Butler, did you have any questions? I'm sorry, I believe you're muted, Mr. Butler.
No questions, Your Honor, and I was able to locate that letter in my emails, and it is on my 3 o'clock hearing. Adam, confused.
Okay, thank you. Mr. Fleming, did you have any questions?
Thank you, Judge. Very briefly, to make sure I'm on mute. Ms. Stewart, regarding the visitation with Nevaeh and her mother, is the department, I'm not quite sure on it, is the department asking for all agreed visitation between the mother and the grandmother and of course Nevaeh, and or the standard visitation? In other words, is the department going to have wording such that as long as mom and grandma are okay with it, she will be able to have time with Nevaeh at any time?
Yes, sir. As long as mom and Miss Julie are in agreement, she can have visitation with mom at any time. Of course, as long as it doesn't conflict with school hours and things like that.
Yes, ma'am. Your Honor, I have nothing further. Thank you very much. I do want to thank our caseworker for her good work during this case.
Thank you.
Thank you. Ms. Jordan, did you have any other questions for this witness or other witnesses?
No, Your Honor, that's all I have. Thank you.
Okay, Mr. Butler, did you have any other witness you want to call?
No, Your Honor.
Okay, Mr. Fleming, any other witnesses?
No, Your Honor, thank you. This is pretty much what Nevaeh wants, so I'm in a complete agreement. Thank you.
All right, thank you. All right, will all parties rest and close then?
Yes, Your Honor.
Yes, Your
Rest and close. Yes, sure.
All right, thank you. All right, the court, having heard the evidence presented and have taken judicial notice of the court's file to the extent permitted by law, and also after hearing the announcement of the agreement of the parties currently present in the courtroom, is going to enter the following findings and orders pursuant to Chapter 201 of the Texas Family Code. The court finds that a request for identification of the court of continuing jurisdiction has been made as required by Texas law, and no other court has continuing exclusive jurisdiction of the child, and this court has jurisdiction over this action. The court finds that all parties entitled to notice have been notified. The court finds that there's been a material and substantial change of circumstances of the child and the parents, the subject of prior orders relating to possession, custody, and access of the child, and that it would be in the best interest of the child for the court to modify those prior orders as ordered by the court. Court finds that any presumption that the respondent father should be appointed as a managing conservator of the child is rebutted. And the court finds that the appointment of the respondent father as a managing conservator of the child would not be in the best interest of the child because such appointment would significantly impair the child's physical health and emotional development. Court finds that the appointment of the respondent mother and the paternal grandmother, Brenda Montag, as joint managing conservators of the child would be in the best interest of the child, with the paternal grandmother having the exclusive right to designate the primary residence of the child without geographic restriction. with all the other rights and duties of a non-parent joint managing conservator under Texas law. Court finds that the court should grant the respondent mother rights of possession and access to the child pursuant to the agreement that was announced by the parties in the court. Court finds that the respondent parents each have an obligation to support the child, and the court should order child support to be paid by each of the respondents based on the minimum wage guidelines for one child with no credit for any other children not before the court, and for the respondents to each be ordered to pay cash medical support, and the court should enter orders for the medical support of the child. The court will therefore enter the following orders. The department is dismissed as temporary managing conservator of the child, and the paternal grandmother and Mrs. Hinojosa are appointed as joint managing conservator of the child, with the grandmother having primary custody as indicated by the court below before, including the exclusive right to designate the primary residence of the child without geographic restriction, with all the other rights and duties of a primary joint managing conservator under Texas law. Respondent mother is appointed as a joint managing conservator with rights of possession and access to the time at such times, places, and under such circumstances as agreed with the with the paternal grandmother, and if in the absence of such agreement, she'll have visitation pursuant to the standard possession order as provided in the Texas Family Code. The respondents are each ordered to pay child support based on the minimum wage guideline for one child with no other child to support. The mother's child support would commence on September 1st, 2021, and continue on the first day of each month thereafter until terminated pursuant to applicable law. The father's obligation would start on the first day, the first month after 90 days after his release from incarceration, and continue on the first day of each month thereafter until terminated pursuant to applicable law. Each respondent parent is also ordered to pay cash medical support, $25 per month to commence at the same time and to continue for the same duration as the child support. The the paternal grandmother is responsible for obtaining health and dental insurance for the child, or enrolling the child in applicable government benefit programs that provide such coverage. And the respondent parents are each ordered to pay 50% of any uninsured medical or dental expenses of the child, or expenses that are not otherwise covered by applicable government benefit programs. The court will discharge, with the court's thanks, Mr. Butler and Mr. Fleming from their appointments 31 days after entry of the final order by the court, reflecting the findings and orders announced by the court today. The court gives notice to the parties in counsel of the right to appeal the court's findings and orders pursuant to section 263.405 Texas Family Code, and the right to request a de novo hearing before the referring district court pursuant to section 201.015 Texas Family Code. Court gives notice that an appeal in a suit which termination of the parent-child relationship is sought is governed by the procedures for accelerated appeals in civil cases under the Texas Rules of Appellate Procedure, and that a failure to follow the Texas Rules of Appellate Procedure for accelerated appeals may result in a dismissal of the appeal. I ask the department to prepare and submit a proposed order reflecting the court's findings and orders today.
Yes,
So I wish you and your child the best of luck, and I hope you and the child will have a good future together as we go forward. Thank you. We're adjourned for today.
Thank you, Your Honor.
Thank you, Your Honor.